All right, 141. I'll get going. Welcome, everybody. I'm Chris Gade. I am the recently termed out co-chair of the AEP 70 Transportation Research Board Committee on Environmental Analysis and Ecology. And we organize a session that is coming up now, and then we will also have a not an official business meeting following this session at 3:30. And so that will just be less formal of people who are interested in talking about that committee. TRB is in a little bit of a reorganizing phase, so we're switching it up a little. So this first session was organized by Jeff France, who is our mid-year meeting coordinator on the committee. And it's going to feature Fred Wagner from Jacobs and Ted Boling from Perkins Coie. So Jeff, do you want to say anything else?
No, I think everybody's probably aware that NEPA is a little bit evolving, so we're lucky to have a couple of rock stars like Fred and Ted to join us and give us some thoughts. So.
Okay, great. I'm going to use the microphone so Ted can hear me a little bit better online. So I'll try not to be too loud, otherwise I wouldn't use the microphone at all. So I'm Fred with Jacobs. I'm a recently graduated lawyer, having practiced for 38 years, 38 years as an attorney, and now with Jacobs as an environmental advisor. Split time in the public and private sectors. Like Ted, worked at the DOJ defending NEPA litigation on behalf of the federal government. And then I was the chief counsel of the Federal Highway Administration during the first rounds of NEPA legislation and reform and streamlining, so we can speak to all that. And my buddy Ted here. Ted, do you want to just say a quick hello?
Hello, I'm Ted Boling, and I'm 34 years in practice, 30 of that in the federal government, and I'm feeling like I'm about 4 years behind Fred now that he's graduated from active practice of law and is at Jacobs. It's a pleasure to be with you today.
Okay, so we are going to start here. It just feels like a tidal wave of stuff that has happened over the last several months, starting from the end of last year and to now. Ted and I have had the privilege of working together and doing these presentations. I'm really glad he's the really small guy on the screen today, because it's the first time ever that we've done a session together where I'm actually taller than Ted. For those of you who know, Ted is all 6'5", if not more. So in any event, I want to talk for a second before we dive into the substance of what's going on, to give you some perspective and to ask you about perspective, which is hard to gain these days with just about everything that's happening. And the perspective is the question, why are we here? Why is this happening? And I'm going to offer two things for you to start that discussion, and then we're going to dive into our session. We're hoping to talk for a little less than an hour or so, and then we really want to have a dialogue with all of you. What are you hearing? What are you concerned about? And we'll give you our best effort to answer these questions. So two things about why this is happening. One is a personal story, and one involves some homework. The personal story. My son went into the family business. He's an environmental project manager, and he tries to build renewable energy projects across the West and the Rocky Mountains of the Pacific Northwest. Very proud of my boy. Very proud. Where was he last week? He was in Colorado. He left on Friday. I came over the weekend. He was in a small town east of the airport near Nebraska called Ray, Colorado. For those of you who are familiar with geography, Ray, W-R-A-Y. And what was he doing there? He was meeting with the town elders about a proposal to build a renewable energy facility in their fair county. And the bulk of the conversation did not deal with how much the landowners would get by offering land for lease, did not deal with some of the things that you all are concerned about, environmental effects, wildlife effects. It dealt with the Greater Prairie Chicken Festival. Not the Lesser Prairie Chicken, the Greater Prairie Chicken Festival. And as my son found out, and he's explained to me, and you can go on the website and you can find this. Once a year, the town of Ray and its surrounding environs sponsors an event where people come in, apparently from all over. They sit in protected areas very early in the morning, and for a couple of hours, they watch the Greater Prairie Chicken in mating rituals and all sorts of things like that. And it's a pretty big deal for this place. And so their number one question was, if we agree to work with you and your company to build this facility, we're worried about how it will affect the Greater Prairie Chicken Festival. Now, my boy being my boy, didn't want to say, and he couldn't say, I'll offer you 10 times as much as you're going to get from all the people that come in and lodge in Ray and eat at Ray for the few weeks of the festival. We could beat that. But because he is my boy, he's wise. And he says, I respect the Greater Prairie Chicken Festival, and we'll tell you ways that we can work with you so that perhaps the festival could be reinvented in a way that people could come, and you'll have both. You can have the renewable energy facility and you'll also have your festival. But I raise this as one of the two reasons why we're here, because it's an example of how, in this case, the Greater Prairie Chicken clashes with the greater environmental good. The desperate need to build more and more renewable energy facilities across the country, which take land, which take property, which have impacts, and now extremely local and legitimate in their eyes, right? And legitimate, I think we could agree. They've been doing this for years. Extremely local needs and priorities that clash with that bigger picture. One reason why we're here. Second reason, and this is the homework for all of you. This is a book by Ezra Klein and Derek Thompson. Ezra Klein, New York Times. Derek Thompson from the Atlantic, called Abundance. Please pick it up. It won't take long for you to read. But in it, they talk about the conflict between the history of environmental law and the history of environmental regulation and the needs that we have today to build infrastructure. And the argument in this book is simply why we're facing this tidal wave right now. Why we're here. And it's easy to say, oh, it's because the political right is trying to fill in the blank, deregulate, trying to take away the authority of the agencies, imposing its own will, perhaps. But the thesis of this book is that the political left is equally responsible. The political left is equally responsible because we have decades now, for decades, stressed process over results. We've gotten really good at process and really good at saying no to things. And so I just want to read you a couple of notes from the book. And this is a quote from the CEO of the Conservation Fund. The environmental movement evolved to stop bad people from destroying the world. And so we have perfected the art of saying no. But we can't say no to the kind of growth we need now. The interstate system is 49,000 miles of road. The interstate clean energy system, solar farms, wind turbines, geothermal, and the like, will touch more than 500,000 miles of land. This is an enormous project, and we have to build and build and build. We can't just say no. And then Ezra Klein goes on, no individual law will address the many different blockages at the many points in the system. What is needed is a change in political culture not a change in legislation. So for those of you who think this is just an attack on NEPA, it is not. It's an attack on our process. He says what's needed here is a change in culture. Liberalism acted across many different levels and branches of government in the 1970s to slow the system down so that the instances of abuse, highways cutting through neighborhoods and whatnot, could be seen and stopped. Now it will need to act across many different levels and branches of government to speed up the system. It needs to see the problem in what it's been taught to see as the solution. Nothing about this is easy, and it is not always clear how to strike the right balance. But a balance that does not allow us to meet our climate and other goals has to be the wrong one. So I encourage you to read this and think about this in the context of what we're about to discuss and all the things that have been going on in the federal government. I would argue that this tidal wave is all about finding that right balance. And both sides of the political spectrum need to participate in it. And this is what we're about to talk about. Can you go one more forward? All right, so Ted is going to go through some of the most recent important developments that some of you may know about. Even since we wrote these slides, there are more still, including from last Friday and this morning, which I will talk to you about. But let's give you the context about what has sort of triggered all this and what you need to be aware of. So Ted, why don't you go through this slide number 6 on the screen, and we'll also fast forward, okay?
Okay, and yeah, I could just elaborate in the way of introduction here. I think what Fred talked about. Well, first of all, can you hear me okay?
Yes.
All right. What Fred talked about, I think, has immense importance for the intersection of transportation and wildlife conservation. You're all very familiar with the issues of island biogeography, of fragmented populations, and the important work of sort of restoring landscape level connections and populations and such. Well, the NEPA process was designed to inform federal agency decision making, has been doing that since 1970, and things were actually kind of boring in NEPA practice. We all knew that the 1978 CEQ NEPA regulations needed to be updated because they still referred to basically paper-based documents, and that there are opportunities to improve on that record, as well as also implement a number of the efficiencies developed, including under the FAST Act, both on the transportation side as well as also the permitting council side. So as we went into more or less like 2020, that's what we were expecting. I was leading the effort at the Council on Environmental Quality as the senior career person involved in the reg writing exercise. I did not expect to have the proposed rules announced from the White House on January 10th by the president himself, along with representative ranchers, miners, construction workers in the background, that sort of thing. And so that started us on this tsunami of changes, a sort of wild ride. And I'm going to run you through where we've been, with highlights being the Fiscal Responsibility Act amendments, which codified aspects of the 2020 regulations, the 2024 case developments, and both in the Supreme Court, the DC Circuit, and then also slopping off into the challenge to the 2024 rulemaking that CEQ undertook in the Iowa versus CEQ litigation. And then wrapping up with where we are now, to a certain extent. Fred and I are going to tag team this a bit in terms of the executive order that one of many that President Trump issued on Inauguration Day, January 20th this year, and then the recent developments since then. So, Fred, if you can advance us to the next slide. Okay, so first of all, the Fiscal Responsibility Act amendments of 2023. They codified certain aspects of the CEQ NEPA regulations. The updated NEPA regulations were largely building on Executive Order 13807, the Executive Order on Discipline and Accountability in the development of infrastructure projects, building on experience with the Permitting Council, with an architecture of lead agency leadership and issue resolution, issue spotting, timeline management, elevation of issues to senior agency officials, all designed to try to move the NEPA process along in a more efficient way. What Congress did was, they codified aspects of that, but they picked and chose sort of like their end point, particularly deadlines for getting it done, page limits, as well as time limits. So 150 pages for an EIS, 300 pages for a complex EIS, which in and of itself was not new. Because that has been part of the CEQ regulations going back to 1978, but it's generally been considered sort of hortatory, aspirational. But now it's in the statute, to the point where the Chief Justice of the Supreme Court took note of it in the argument of the recent NEPA case, the seven-county case. And then perhaps more significantly, time limits. Where you actually have a provision for judicial enforcement of these time limits. You also had, codification of other aspects, definitions and also a provision for, CEQ with regard to improving data sharing amongst agencies. But what it didn't address was sort of the routine scoping judgments, including, just how far out do you reach in terms of cumulative effects, providing CEQ with an explicit basis for its own rulemaking authority. Those regulations had been on the books since 1978, based on a 1977 Carter administration executive order, and largely codifying guidance that was developed in the Nixon administration pursuant to an executive order. But CEQ missed an opportunity to codify that. And then it didn't really address, other than codifying the familiar language of reasonably foreseeable, it didn't really codify much of the regulations developments on scoping of impacts, including addressing impacts that are and alternatives that are outside of an agency's jurisdiction or ability to control. So next slide, please.
Yes, and when I advance, Ted, let me just add to your comments that we know that they didn't do a lot because some of the preliminary and early drafts of the Fiscal Responsibility Act had a lot more stuff. So what it ended up being was a lot less. And ironically or not, some of the stuff that was left on the cutting room floor is now working its way back again into proposed legislation. Query whether it'll work its way into some of the things related to the budget bill. We'll see how far they want to push, but it's certainly been reintroduced in terms of some of the other permitting and legislative reforms, a lot of which have very little to do with NEPA per se, and a lot to do about the litigation and challenges to NEPA actions after you all are done with your work.
Yeah.
And arguably a lot of what the objections to the quote NEPA process in quotes is not so much the NEPA process, but what happens afterwards. And some of the uncertainty that's introduced by litigation. But we know a lot was left on the cutting room floor. Ted mentioned the one part, the CEQ lost the opportunity to say, hey, we really do have the authority to issue these regs, and then bit them in the tuchus.
Well, and I could just elaborate on that. I mean, the chief negotiator for the House was Representative Garrett Graves, who was the chief sponsor of the Builder Act and has been a proponent of NEPA reform throughout his tenure, and takes an active interest in being from Louisiana, particularly in Army Corps of Engineers projects, but the full range of it. And the negotiations were more or less sort of a reductive exercise down from the Builder Act because this was more or less undertaken over a weekend with the fate of the Western world and the economy hanging in the balance. It was attached to the provision that increased the borrowing authority of the federal government. So you basically had the full faith and credit of.
The debt limit crisis. Remember the debt limit crisis was everything we were really worried about? But that's what the Fiscal Responsibility Act was. The NEPA reform, the amendments to NEPA were part and parcel of a budget action because they had increased the debt limit. So again, only so much to get in there.
Yeah. Well, all right. So the next step in our drama in 2024, so this is after the CEQ had issued its phase 2 rulemaking, because it took about 3.5 years for CEQ to complete its cycle of updates of and amendments to the 2020 regulations. So that summer issued the CEQ NEPA regulations. They were promptly sued on by 21 states in Iowa versus Council on Environmental Quality. And while that case was pending, in fact, just a week before oral argument in the summary judgment motions, the DC Circuit came down with the decision in the Marin Audubon Society case against basically an air tour management plan that the Federal Aviation Administration and the National Park Service had come up with to govern air tours around in San Francisco Bay. So an urban area, not which you'd consider to be sort of like a hotbed of, preservation efforts to preserve natural quiet, which was what, air tour management is all about. But it took them about 20 years to come up with this plan, and their plan was basically, cementing in place an interim plan using a categorical exclusion. And that was really the heart of the case, is whether this was an appropriate case for a categorical exclusion. Categorical exclusions, of course, exist in agency NEPA procedures, the FAA and National Park Service. The CEQ NEPA procedures were not at issue in this case. However, in invalidating the air tour management plan, the majority opinion went on to find that the CEQ NEPA regulations lacked any basis in law, that there wasn't an explicit grant of congressional authority, that you needed that for purposes of impacting the rights and responsibilities of regulated entities, people coming to the agencies for approval, for funding and authorization and what have you. And so that caused quite a stir. Its timing was well designed for impact both on the incoming presidential administration as well as also on the pending litigation in Iowa versus CEQ. I put in here on the last bullet here, I mean, the end point on this, I mean, all parties sought rehearing en banc because this was an issue that was never briefed by the parties. It was not directly at issue. And that petition for en banc review was denied, but with a note by the DC Circuit that saying that that the case is appropriately remanded, and that there's given that the majority's rejection of the CEQ regulations was really outside the scope. It was unnecessary to the panel's disposition and therefore should have no force and effect. However, next slide, please. Well, we've got the. Go ahead.
Yeah, that's the Iowa case. Yeah.
Yeah, there's the Iowa case. The court in Iowa versus CEQ, which was actually argued in North Dakota, asked for supplemental rule briefing, and it also, following the briefing, found for the plaintiffs in that case. Actually, we can go to the next slide. But bottom line, it's held that CEQ lacked authority to implement binding rules. But then it also argued it made rulings in the alternative, because this case will be, it's appealed and it will be pending before the Eighth Circuit. And so it did go through the CEQ regulations, the 2024 regulations, and in some fairly important, lasting significance for environmental impact analysis, particularly for, the upcoming revisions of rules that we're under now. It actually rejected the challenge to the CEQ regulations incorporation of climate change and environmental justice considerations. In other words, sort of implementation of executive orders that have been, were issued by President Biden, have now been withdrawn by President Trump. In remanding to the agencies, it reverted the CEQ regulations back to the Trump administration regulations. I mean, it's basically the Trump regulations as amended in some very small respects by the Biden administration. Next slide.
Let me do a quick recap here, so people will do the timeline. So you're following this, we're going to insert one other thing. So July of 24, the NEPA rules are finalized. Litigation ensues to challenge the final NEPA regulations. Marin Audubon comes down saying CEQ has no authority to issue the regulations in the first place. The litigants in the challenge to the phase 2 NEPA rules, the binding rules, insert that finding in their case. And then in February, the court in North Dakota says, you know what, the DC Circuit was right. CEQ didn't have authority to issue the regulations at all. So from July to February, you went from brand new regulations to no regulations whatsoever, according to the courts in the DC Circuit, sort of. They tried to disavow it, but sort of. And then definitely the court in North Dakota in the challenge to the phase 2 regulation said no go on the CEQ regulations. All that happened in the course of 5 or 6 months.
Yeah, and actually, it's even it's even weirder than that, because first of all, add to the weirdness here. I've never been towered over by Fred Wagner like this.
I'm liking the feeling, Ted. It's the first time I can post you up in the lane.
I'm sorry. I feel for you, but okay. So literally, what the Trump administration has done is now ordered that the regulations to be rescinded were the regulations that are largely promulgated by the Trump administration. So President Trump in Trump 2.0 has reversed President Trump in Trump 1.0. It's a strange state of affairs. But it's kind of maybe par for the course as we've got right now. If we can go to the next slide, please.
Do you want to reinsert Sutton County as part of the last piece of the chronological puzzle? We skipped over it.
Well, we're going to go back to 7 county.
Okay.
Let's finish out with. All right, fine. You're in the room. You're in control. Let's go to 7 county.
Let's go there. Okay, so there's one other piece of the chronological puzzle. And this happened in the case that I just litigated in the U.S. Supreme Court, the 7 County Infrastructure Coalition case. A railroad being proposed in rural Utah, an 88-mile railroad that was approved by the Surface Transportation Board. That was the lead federal agency. We were challenged by a bunch of folks in Eagle County, Colorado, and other environmental groups. And when we got to oral argument in front of the DC Circuit, it was a 2.5-hour oral argument. 0% of the argument dealt with the 88 miles in Utah. 0%. 100% of the argument dealt with upstream and downstream effects stemming from what the rail line would transport. In this case, the main impetus of the railroad is what's called waxy crude, waxy, W-X-Y, waxy crude, which if you think in your mind, think of the consistency of a candle. That's what waxy crude is, has to be heated up in order to become a product. It's used in a whole variety of products, you know, medications, pharmaceuticals, you name it, etc. So it's not like crude oil like in a tanker, it's waxy crude. But the arguments revolve around what would happen when the waxy crude is transported to refineries all across the country, most specifically refineries in Louisiana, which is over 1,500 miles away from Utah, and then refined in those places. What about the air impacts from that in Louisiana? So for 2.5 hours, we had this argument in the DC Circuit, and we lost. The DC Circuit said the Surface Transportation had to do more in terms of upstream and downstream effects. And we asked for en banc review of the DC Circuit, were denied, and then decided to appeal to the Supreme Court. And lo and behold, for those of you who aren't lawyers, do you know what percentage of cases the Supreme Court takes in any given year when people petition to ask the Supreme Court? Anybody? It's about less than 1%. And we got one. We were one of the 1%. And so on December 10th, so remember, all this is happening. The appeal to the phase 2 rules, the McMahon Audubon case, and then on December 10th, we're in front of the Supreme Court arguing this case. And the sole question is, how far do you have to go? How far do you have to go? And remember when Ted correctly said that the Fiscal Responsibility Act did not answer that question? This case, in theory, will. And it's not based on the regulations. It's literally based on the statute. It's on NEPA itself, not based on the CEQ regulations. And the petitioners, us, we proposed a rule for the court that said there's a way to think about this. And the way to think about this is that you should be taking into account, when you do your analysis, effects that are reasonably close in time and space to your action, and those things that are in the jurisdiction and control of the lead federal agency. Close in time and space and within the jurisdiction of the agency. So, by contrast, the 80 miles of road, the ground disturbance, the things like that, the air effects from building the road, construction, the air effects of operating the train, all fair game, reasonably close in time and space. The air effects of refineries in Louisiana or elsewhere in the country, not so. We don't know when they're going to get it. We don't know how much they're going to get. We don't know if those refineries are even going to be open at that time. SDB doesn't permit those agencies. EPA does, or state agencies do. That would be a no. And the question is, what's going to happen with that decision? And as Ted has correctly summarized here on this slide, Ted, you want to go over it. These are kind of the two results that could come out of the case.
Yeah, if I could just add, Fred, I mean, adding to the unusual nature of this case is the fact that the United States, the Solicitor General's office, opposed seeking a cert in this case. And so, I mean, when the SG's office petitions for cert, there's a high likelihood that you're going to get it. But do you have a figure for how often cert is granted over the opposition of the United States? It strikes me as relatively rare.
No, that's right. It was like first they were against us, then they were for us.
Yeah, well, they're on the same side of the V. I mean, it's strange bedfellows, but basically what the U.S. was arguing for, and the great Deputy Solicitor General Ed Needler was asking for basically a deference to agency expertise. That what the Court of Appeals did was basically fly-spec and otherwise fine analysis. I mean, the Surface Transportation Board looked upstream at the likely development of waxy crude resources in the Uinta Basin based on the existence of an 88-mile railway line. And then they look downstream at the risk of ninefold increase in train traffic on a particular leg of the Union Pacific Railroad, and likelihood of increase in accidents, spills, as well as also the downstream effects of, well, this is going to a refinery, and we kind of know there's a handful of refineries out there, and they stopped at what they thought was an appropriate point, and what the DC Circuit did was say, no, we think you could go farther. It's sort of, we think you could do more, and that this case is like another case where it was easier to calculate the downstream effects.
And we only have 8 justices. One of the justices recused himself. The justice from this part of the world, Justice Gorsuch, recused himself, which is in itself highly unusual. Everything about this case is unusual. So we have 8 justices, and I would argue we have 8 justices for the first alternative approach that Ted talked about. Nobody liked the DC Circuit's ruling. Justice Jackson didn't like it. Justice Kagan didn't like it. Nobody liked it. They all said they went too far. They shouldn't have fly-spec the STB in that way. But then the second approach, what I'll talk about, is this rule that we proposed. And the question is, are there 5 votes to establish a new rule? That's the key question. Now, when are we going to find out? The Supreme Court has resolved every case that it's heard in October, November, and December, except 3. And we're one of the 3. The Supreme Court announces when it's going to issue decisions, but it doesn't tell you what decisions it's going to issue. The Supreme Court has announced a decision day for this Thursday. There's only 3 cases left from those earlier months that they haven't argued. So I'm literally on my computer at 10 a.m. Eastern time, so it'll be 8 a.m. out here. Thank you. And I'm going to be refresh, because they literally just announced it and they post the ruling online. That's when you find out if your case has been resolved. So we will potentially find out this Thursday, which is going to be a momentous Supreme Court day, because they're also hearing the birthright citizenship case on Thursday. So if you're thinking of going to the Supreme Court on Thursday, don't, because the line will be wrapped around Washington, D.C. But you could hear the 7-county infrastructure ruling on Thursday morning at 8 a.m. Mountain Time. At least maybe. And I think it's going to be one of these 2 results. So, do you have this wacky timeline? New regulations, challenge to the regulations. Marin Audubon, you can't regulate. Supreme Court, we're going to tell you what the regulations mean, but there's no regulations. Executive order, no regulations, revoke them. Now write new regulations. That's all in 5 or 6 months. All right, so now we're going to get to the point of, okay, all this happened, I caught you up. I'm sure you all understand it tremendously. And we're going to get to kind of what happened here with, where the rules are and what's going to happen moving forward. And that's kind of, I think, the introduction to the February CEQ order, telling every agency to rewrite or revise their own NEPA regulations.
And actually, Fred, I got you at slide 13, Executive Order 14154.
Got it. I'll go there. Start talking. I'll meet you there.
All right. Well, that executive order, so I mean, we're trying to go in chronological order. So the reason we hit this point was because that was the next step after the oral argument of the 7-county case, was Inauguration Day. And as you probably recall, there are about 85 executive orders issued. And in section 5 of the Unleashing American Energy executive order, you had this, what, was a rather surprising provision in there, revoking President Carter's executive order, which was basically an amendment to President Nixon's executive order implementing NEPA and directing CEQ to issue guidance. The Carter executive order said, go one better, convert your guidance into regulations that are binding on federal agencies. So that's revoked. CEQ was directed to propose to rescind its NEPA regulations, and to lead a interagency effort to update all the other agency NEPA regulations, the ones that currently all queue off of the CEQ regulations, which
I
have
would
ceased to
argue that
exist.
the proposal to rescind was kind of like when you propose to your child that they should go to bed. You know, that's the kind of proposal I think that was.
Yeah, although, I mean, the limits of the direction is not any specific timeline there. I mean, they could have proposed to rescind them effective, 1 year from now when all the other agency NEPA procedures are in place, updated.
Right.
So, but, the whole basis of this exercise is to, update agency NEPA procedures, reflect the deadlines of the Fiscal Responsibility Act and the requirements there, to prioritize efficiency and certainty, and other, the objectives of executive orders over, the objectives of project opponents, and avoid delays. So now you can go on to the next slide.
And again, what's fascinating is, again, this goes back to as our clients spoke in abundance. It's like, whoever sets the priorities sets the agenda. If you read this executive order, it's streamlining and efficiency over all other priorities. Really? Over all other priorities? That's a lot of priorities that elevates over. What Ezra Klein argues is that what we should be prioritizing are positive outcomes over all other things, even to the cost of additional process. So this raises the question, who gets to set the priorities? And so the executive order here was clear, and as we'll see shortly, there have been other actions since that have acted to implement those sets of priorities. So stop me.
So let's move up to
20?
up to slide 20.
Yep, there you go.
There you go. All right.
So
So another surprise. CEQ issues its guidance memo along with its proposal to rescind its regulation, or rather its interim final, actually rescinding its regulations.
on the exact day that was in the other executive order, did you notice? They said by February 19th, this was issued on February 19th.
Right. And so this guidance tells the agencies that they should rely on the rescinded regulations in the interim as they're defending their projects. I don't know if Fred can address exactly why, how you actually rely on rescinded regulations, but that was literally the guidance. And
No,
that agencies.
Ted, I'm a
Yeah.
very good ex-lawyer, but I'm not that good.
Yeah. And then agencies are on this mad dash now to update their NEPA procedures. And it also says that they have to do a public process for updating their NEPA procedures to the extent it's required. But in their rulemaking, where they got rid of their own NEPA procedures, they argued, well, we've got good cause to do this as an interim final rulemaking. We'll take comment before it's actually effective, but these are just rules of internal agency procedure, and we could do it without any notice and comment, an exception under the APA. Well, that drew some reaction. You had groups like the Chamber of Commerce saying, wait a second, all right, so we really actually like NEPA regulations. We like, they weren't opposed. No one was in the early days of the Trump administration actually going to stand up and oppose these this effort to rescind the CEQ regulations. But they did say, the chamber was focused on, we need predictability. This is important for project developers, for finance. I mean, we need to have some degree of certainty that that the NEPA process will proceed according to a timeline, orderly decision, that it will be efficient. that, we've got the people necessary to actually implement this, and that we will do it in a transparent way. In other words, that the regulated community as well as also the public will have an understanding of what CEQ is up to, what the agencies are up to as they're moving forward in their process.
What's fascinating about this, Ted, is that this is the Chamber of Commerce for crying out loud. This is an entity that you would think would be saying, go for it. No regulation is a good regulation. Less regulation is good. But here you have the chamber saying, no, remember the priorities of the executive order, streamlining and efficiency above all. They've added predictability in addition to efficiency and transparency. And that's from the U.S. Chamber of Commerce.
Yeah.
And this has importance because while this is going on during this whole rigmarole of it's being revoked and now what the agency should do, this is a little bit of inside Washington baseball, but this is what we can offer, and you kind of love those juicy tidbits, don't you? This is good. There was a draft memorandum that went around to all the federal agencies telling them that they should all rescind, revoke all their internal NEPA regulations and rely solely on guidance. We know this is true because the media got a hold of this draft memo and they put it in the press so we could read it. Kind of like the signal chat about when we were going to bomb the Houthis. It was all out there. It was all out there. Well, that caused it quite a stir. Like over the course of a weekend, this came out on a Friday. Over the course of the weekend, and by Monday, the mainstream media had picked it up. And there was a firestorm even within the federal family, led by my former agency. The U.S. DOT, the Federal Highway Administration, who has joint regulations with the Federal Transit Administration and the Federal Railroad Administration. As you all know, the regulations of 23 CFR 771 are amongst the most mature NEPA regulations in the entire Code of Federal Regulations. There's 52 state DOTs, including Puerto Rico and the District of Columbia, plus all the transit agencies and private rail developers that have relied on those regulations for decades. And arguably they work. Well, they threw a SBIT to the White House saying, we don't want to revoke those regulations. They're too important. Consistent with this, consistent with the Chamber's point of view. It provides predictability. It provides transparency, and it's working. Don't do this. And they weren't the only ones to do that kind of begging to the White House. And within a week, just like, the tariffs, they're up, they're down, they're in, they're out. The policy goes back and forth. Within a week, they said, okay, some of you can keep it, but we still certainly want them updated to reflect our policy objectives. So we expect some of the agencies with the mature NEPA regulations to update them. They'll have to, in a minimum to reflect the Fiscal Responsibility Act, and a minimum to reflect some of the goals and objectives of the 2020 regulations that Ted told you are now really what's sort of kind of being referenced by the administration. But then there's going to be other entities like the Surface Transportation Board that doesn't have any NEPA regulations at all. The Federal Energy Regulatory Commission. Anybody do transmission lines? Pipelines? They don't have any regulations at all. So they're going to have to create regulations consistent with all this stuff. So the order about revoking, rescinding, and rewriting is still in effect, but our understanding is that it's going to be implemented differently, agency by agency. What does that do for predictability? Arguably. So Ted, what I'd say is, why don't you summarize just a little bit, a couple of the other notions from the comments, and we'll go then to kind of what's...
Yeah. Okay, so next up on the slides there, the Western Urban Water Coalition actually did, this is, like Denver Water, Aurora Water, most of the metropolitan water systems, Colorado Springs included, around the West, argued against rescission of the NEPA regulations, basically saying, this is going to cause significant disruption. And in particular, highlighting that's coming at a time when you've also got brain drain in the federal government, and asking for CEQ to cool it, suspend your effective date for your rescission, and issue, use your regulations as model regulations. Use the 2020 regulations as guidance for agencies as they're moving forward with this. Actually, next slide, AASHTO weighed in, predictably on behalf of the states where, you've got a lot of delegated authorities and, trying to operate under MOUs that are fixed in time based on, Part 771 and, the CEQ regulations and sort of a baseline of law there. And, again, there's a great deal of concern about, that, they're going to be able to adapt to this new, and actually lead in this new complicated environment. And then, okay, you've got American Exploration and Mining Association. I've got that as an example as one that actually supported CEQ's actions. But then they also went on and said, but we need these things, and in the NEPA procedures, and we want to have, a rapid transition to these, multiple, but hopefully coordinated agency NEPA procedures. You can move on to the next slide.
All right, so I told you that, let me interject. Yeah, let me interject here just one thing. So I told you there was late breaking news and there's other stuff that's, again, consistent with everything we're just hearing. So 1 week ago, the Secretary of the Interior, Bergen, announced a new policy that fed off of the initial executive order. So remember the first executive order we talked about, unleashing American energy? What was the basis of that executive order? Why did we have to unleash energy?
Energy emergency crisis.
Say it loud, say it proud.
We were in an energy emergency crisis.
We were in an emergency. We were in an emergency. We're in a trade emergency. We're in an energy emergency. We're in an immigration emergency. I have to go to the bathroom emergency. We're in a lot of emergencies. That was the basis. I do kind of sort of, but I'll be tough. But the basis of the emergency order said we're going to accelerate our approvals for oil and gas, not all energy, just certain kinds of energy, for oil and gas, so that environmental assessments are going to be done in how many days? 14. Not 15. And EISs are going to be done in how many days? 28. We're going to do EAs in 14 days. We're going to do EISs in 28 days for certain types of energy approvals. Friday. So that was the announcement. Friday of last week. I told you it was late breaking stuff. The 15 Western states, led by Washington State and California, and litigation brought in Seattle, challenged, finally, I was waiting for this to happen, and it hadn't happened yet. They challenged the declaration of an energy emergency. They said, you just can't say the word and then change all your procedures. But why? The reason, why did they say that? They said it for two reasons. One, there is, believe it or not, a law called the National Emergency Act that Congress passed, and they ignored that. I didn't really know about the National Emergency Act, but I'm glad there is one. But more importantly, they said each and every one of the procedures administratively that you are now relying on to accelerate, remember we're expediting what? Efficiency and streamlining above everything, right? Because the emergency, we're emphasizing that above everything. Each and every one of the places that have procedures for that, the Army Corps of Engineers, the Advisory Council on Historic Preservation, the Fish and Wildlife Service, NIMS, what do they all have? They all have regulations about emergencies. They're already written. They are already there. Some of us in this room have probably implemented some of those instances after forest fires, after floods, after things that you need to build quickly to recover. There are procedures for emergencies, right? NEPA itself has a procedure for emergencies in the old regulations, which were rescinded, but it was called alternative procedures. where if there was something you had to do quickly that otherwise would require you to review, you could do an alternative procedure, and it's reserved for emergencies. So they sued on three bases. One, you didn't follow the National Emergency Act. And then under the Administrative Procedure Act, they said, you're not following your own regulations. You have regulations to declare emergencies. Why don't you just follow them? And third is again, remember I said, the tourists, now their own rationale about no CEQ regulations, there's no basis. There's a term for that legally, even though I'm not practicing law, I can say it, ultra-virus activity. What the states are saying, your declaration of emergency, just because you say so, is ultra-virus. You don't have the authority just to do that. And that case was just filed on Friday in Seattle. And the last thing said, and I'll go back to it. So then what happened this morning? Well, I was prepared for this freaking talk. What happened this morning? Doug Burgum announced the first EA subject to the 14-day limit for a uranium mine in Utah. For a uranium mine in Utah. I think the basis is that it was an existing mine, it had been shut down, they're trying to reopen. Again, there's an emergency because we need more uranium. There's the word again. And they just announced they're going to do a 14-day EA just this morning. So Friday is the litigation to test whether you can declare an emergency. This morning, they're actually going to try to implement it. And it's unclear how fast the court is going to go. We don't know. So the court may act pretty quickly now that there's actually a proposal to implement this 14-day rule, but that remains to be seen. The case was just filed on Friday. So we don't know. So when I told you things were late breaking, they were. So, Ted, do you want to go back to kind of where we are now and what we expect from the agencies? What's the best way to do this now?
Well, I would just add, I mean, certainly, there are slow-moving emergencies. I mean, I'd say like, at one point, the Louisiana came to at the beginning of the Trump administration came arguing that the coastal erosion was an emergency, and therefore we ought to grant emergency alternative arrangements to the Mid-Barataria project to restore sediment to the coastal Louisiana. We said, no, let's put it on Fast 41 and really deal with the management issues, the interagency coordination issues. But I think one sort of emergency we've got in NEPA practice is just the raw number of environmental impact statements that are being produced. I mean, we're big.
About one point. I'll be done while you talk. I'll point.
Okay. All right. So if you look at, historically, to get big things done, big infrastructure projects done, it's probably an environmental impact statement. You can only categorically exclude your way, so far. And we typically had, between 500 and 250 EISs per year. By 2010, we're down to like 200 EISs per year. But during and then during the Biden administration, well, during the Trump administration, a high point of 128 EISs, and then we dropped down to like 62, 63 EISs per year in 2021. 2023, 2022 was not much better. A full 100 EISs produced in 2024. And so far this year, at least in the first quarter of this year, we're on track to be, hitting the lowest number in the Biden administration. So, it kind of gets back to Fred's point about what does it take to get big things done? You can go to the next slide. I just encourage you to watch this space. On the technology side, this is actually a continuation of work that started in 2024 and actually has an even longer lead time than that. And that is just accelerating our deployment of the technological means of making our permitting processes more efficient. OMB has issued a memorandum on driving efficiency. CEQ is is commanded to issue a permitting technology action plan, which is largely building on something that the Biden administration produced last summer. And in that permitting technology action plan, move on to the next slide, please.
Yes, sir.
You're gonna it's really gonna it's digging into just the problems of with application protocol interfaces, the connections between agency databases, using the General Services Administration and 18F group to really establish the minimum requirements, a roadmap for the data systems that agencies are using, as well as also, next slide, please. They've got a sort of operational side of this. Mind you, they don't have a chairman at CEQ yet. That person hasn't been nominated yet. But that hasn't stopped the Trump administration from directing that CEQ established this permitting innovation center to facilitate the software, the data sharing, using the resources of 18F, the database mavens at GSA. And I will say, based on my conversations with folks at CEQ, I mean, there's very much a GIS quality to all this. I mean, it's sort of the data tools that environmental professionals use on a daily basis, designed to be made more available, more accessible, and interoperable between agencies. So let's go on to what's next, because we need to make time for questions here.
Yeah, let me just ask one quick question. Is anybody here also at the National Association of Environmental Professionals in South Carolina? I apologize if you heard this all before, first of all. But how many sessions were there on the application of artificial intelligence in NEPA? How many? About a quarter of all the sessions were about the use of AI in NEPA. A quarter. And this dovetails nicely into the CEQ's objectives with the innovation. And ironically, very bipartisan. And it's at the same time exciting and troubling for professionals, let's admit. But the exciting part is that maybe you don't have to be out in the field, counting this, that, or the other things. Maybe there is databases that are reliable, where instead of doing it from scratch, you can double check it, making your time, instead of making the number of 100 hours 10. Maybe you can come up with preliminary mapping to help direct you to places where there are better alternatives for things. More than a decade ago, one of Ted's dear friends, was the shepherd of the Smart from the Start program. Does anybody remember that from the Department of the Interior? Smart from the Start. What was the objective? If we want solar and we want alternative energy on public lands, let's figure out where they shouldn't go. And so Smart from the Start was basically a giant mapping exercise to try to figure out, well, if we can take out these places, we'll just eliminate those from consideration. Then the places where we're building will always have challenges, but at least it won't be hard stops. Think of AI as like the next generation of Smart from the Start, in a way that you can map and understand where the sensitive resources are, where things absolutely shouldn't go, maybe where things have gone before, so that you can accelerate your assessment of cumulative effects. So there's a lot of possibilities to all of this. And absolutely 100% will be an emphasis of the administration. And I won't hesitate to say that's a good thing. And you all play a part in that, to try to figure out how can it work best. What are the places where we know there are gaps, and how do we fill in those gaps? So this is a huge issue. So we promised to finish in about an hour. So these are some of the things that we expect to be happening next. We will soon see some of the initial agencies come out with their guidance / new regulations. In 2020, my former agency DOT was first out of the box. Good for them. It was 3 months after the 2020 regs, and they said, "Oh, we're not going to update ours to reflect those." So it took 3 months, and that was really fast. So prediction. This was ordered in February. By the end of the summer, I would argue, during the summer, maybe early fall, you're going to start seeing some of them roll out. So we're going to see what the agencies have to say. Maybe we'll hear Thursday morning what the Supreme Court says about the scope of review. Maybe there's gonna be a new test. Maybe there won't be, but we may hear soon. And then, we know that the challenge to the CQ regulations that Ted talked about from the Iowa case, that's on appeal to the 8th Circuit. For those of you rooting for a reversal, and you have the sports book on your phone, do not bet on a reversal, because the 8th Circuit has 12 judges and 11 of them were appointed by Republicans. It's very, very conservative bench. I don't expect the district court to be reversed, although stranger things have happened. And so that's on appeal. And then we're going to see about the emergency declaration. How far does that go? What authority does that give the administration, yes or no? All right. So these are the things that we expect to see, and it all will be happening over the next 3 to 6 months. And if you came back and you put yourself in a time machine and you heard Fred and Ted show 6 months from now, this could be completely different. I could be on the screen, he could be live. Who knows? But that's really what's going to happen. So what we promised was to have a dialogue now with you all. You're all the experts. You guys do this every day. You coordinate people do this every day. What are you hearing? What do you want to know? What are the kind of burning questions that you have? And first you'll hear from Ted and me, just from our perspective, but equally I want to hear from all of you. So we have one mic. I will run around the room. It's a small room, so I won't get that many steps in. If you have something you want to ask, something you want to talk about, I urge you to do it. This is a pretty unique opportunity. Because between Ted and I, between federal and private, we're talking about just shy of 80 years of doing this stuff. So here's your time. I'm sure Jeff has one. Fall right back. How are you?
Not particularly related to NEPA, but the Endangered Species Act and the definition of harm. How does that play into all of this? And what's the status of that? How does it play into NEPA? Does this just throw another wrench in the whole thing?
Great. Hey, Ted, if you didn't hear, that was what's the interplay between the proposed redefinition of harm under the ESA and all this stuff?
Oh, well, I think it could be hugely significant because you've got a freestanding obligation in NEPA to consider environmental effects in reaching, habitat effects. I mean, the ecological effects. I mean, NEPA was one of the first statutes to refer to ecological effects. And, it did that before the 1973 amendments to the Endangered Species Act. And so, redefinition of harm, and the more you cut away the architecture of other statutes, you've got NEPA in its sort of backup support function coming into play. And so, if the administration were to adopt, say, Justice Scalia's opinion of the scope of harm in the Sweet Home decision, as opposed to what we've the regime that we've been living under, and frankly, the one that respects the life history of threatened and endangered species and their habitat dependencies, then I think you're probably going to have some pressure on the NEPA process to pick up the slack.
Yeah, and I think that it's equally true in terms of picking the slack that if they do change the definition to exclude degradation of habitat, I dare say the driving force of this whole freaking conference falls under question, because it isn't the development of a highway that necessarily takes more species, and everything that we're doing in this realm can generally fall into the realm of mitigation. And so if the concept is, and literally you have to read the dissent in Sweet Home. So Ted talked about it's another Supreme Court case, Sweet Home versus Babbitt, was it Babbitt? And there was a majority ruling that upheld the regulation of including degradation of habitat as harm. It was upheld. 3 justices dissented, and the basis of the dissent was almost a literal, you have to reach out, grab the mule deer by the throat, and twist. I'm not exaggerating. It was almost that express. Killing means literally killing. And so that's a direct action, not an indirect action. So arguably, a lot of things that we are planning for and talking about in this conference are as a result of indirect effects of the thing that we are doing. And we mitigate for those indirect effects because we have a history, we have data, we have information and stuff like that. But if that falls out, yeah, there's going to be pressure for NEPA to fill in the gap, but there's going to be equal pressure from a Republican Fish and Wildlife Service not to fill in that gap. So, I mean, this is a dreadfully important proposed rule. The comment period is up. Parties have asked for an extension of the comment period, they won't get it. So I think the comment period is up sometime this month. The 19th? That number keeps on coming up. It was February 19th. So yeah, it's coming up very soon. And then they're gonna, again, it's kind of like the proposed revocation. You know they're just gonna adopt the sweet home minority. And then the question is, as with all these cases, then there will be litigation. The same parties that were on the sides of Sweet Home will reemerge 30 years later, and we'll be litigating that. We'll find out. And then, ironically, the issue about deference to an agency's interpretation, the Chevron deference that's no longer there, it's now called Loper-Bright, the Loper-Bright decision. Irony of all ironies, the conservative movement fought to overturn Chevron. Now they're going to deregulate. They're going to be sued. Why? Because you shouldn't defer to the agency. Because the statute is clear. And if you read the Sweet Home majority tag, you'll see it's based some on the interpretation of the regulation, but just as much on interpretation of the statute. And the majority said we cannot read a more broadly worded statute that elevates the preservation of species, including habitat, more than the Endangered Species Act. And in order to reverse that definition, the new Department of the Interior Fish and Wildlife Service NIMS is going to have to be arguing just the opposite. That you should defer to our interpretation of the statute, which the Supreme Court said 30 years ago couldn't be more bloody clear. So again, turned out fair play. They didn't bit the hooks by Loper-Bright instead of having Chevron there. So that's the long answer to a short question, but one of the top 3 most important environmental proposals that are out there in the administration right now.
Follow-up.
No follow-up, I'm kidding. Is this a White House press conference or something?
Science in this. I mean, they're just going to say, okay, we got comments. Thank you for sharing. We're going to move ahead. Where's
A loaded question, Ted. What is the role of science in all these developments? Where does data, science, findings, how does this all fit into what agencies are going to be able to do or not do?
Yeah. Well, I mean, ultimately, agency decisions are reviewed under the Administrative Procedures Act. They have to draw the connection between the facts found and the conclusions drawn. That's just kind of basic to administrative law. The CEQ regulations had, for a long time emphasized, high quality environmental information, and, where you're at the limits of incomplete and unavailable information, you need to identify the limits of science and identify your sources and your means of making an impact assessment. So, I mean, I think science, underpins everything that is done under NEPA. It really goes to the question, well, how do you know? What do you know about the effects of a given action? And the policy direction, ultimately can only go so far to dictate choices. The NEPA process is designed to inform those choices, and if the NEPA process doesn't do that, then that it will be at least open to challenge. Set aside whether it's actually challenged in court or not. It will be open for challenge.
Yeah, I totally agree. And the other thing I'd raise, the one thing that did get into the Fiscal Responsibility Act is the principle that unless you really have to do something brand new, there is no obligation to do new science, new studies to defend the NEPA analysis. What this is designed to do is to defeat the trend that we've seen over the years, where parties that oppose your project, not only say you're opposed and you're too fat and all that, besides that, they add a dozen or more studies from around the world and whatnot. Say, hey, Dr. Smith said this, Dr. Jones said this. What about that? You know, you gotta be dealing with that. And so the question always here, you as the lead agency, you as the folks, how do you deal with that now, right? Do you have to do something brand new? Do you have to deconstruct each and every study that gets lumped into your administrative record? That caused delay, that caused administrative paralysis. The fiscal responsibility says you're under no obligation to do a brand new study just because you get that type of information in the record. On the other hand, you should be cognizant of what is there and be prepared to discuss it. Again, is that another role for AI? You betcha. That is an unbelievable role for AI, because instead of saying, throwing up your hands and saying, well, we don't know, just because Dr. Jones from New Zealand said something about these effects in 1998, how are we to know? ChatGPT, give me all the studies that talk about Dr. Jones' theory. The theory you could be seeing. The ones that cited, the ones that not. If Dr. Jones is cited 0 times, that may tell you something. If Dr. Jones is cited frequently, but distinguished, that might tell you something else. So yet there's, again, going back to the AI point of science, I think there is an opportunity to elevate our science game by getting better access to the scientific data and findings that are out there. And instead of throwing up our hands, say, well, are there trends here? Is this a majority rule, minority rule? Is this something where the community is literally split 50-50? Is this something where they threw in Dr. Jones and Dr. Jones is a true outlier? In which case you can say that. And that's good for your administrative record. You don't have to be shy. If somebody says, oh, Dr. Jones says this is true, and you find that nobody else agrees with Dr. Jones, it is a simple point to make it a final EIS in response to comments. If we've looked at Dr. Jones, nobody else cites it with authority. It is a minority view. Thank you for your comment. You will win on that every day. That can be AI assisted. So, Ted's absolutely right. It's the basis of everything we do. You can only make it go so fast. But if we're good about sharing data across the federal government, if we're good about saying, hey, there was an EIS done in Utah right down the street, why don't we do that? And it's a bad excuse to say, well, AECOM produced that EIS and we're HDR, and so we have proprietary obstacles. That's a bad excuse. It's a public document sponsored by the federal government, state government. AI can help with that. And if we, as a community, come together to say data sharing, scientific sharing is a good thing, that could do nothing but promote efficiency.
I'm curious if you've seen EO that recently came out that zero budget or zero based regulatory budgeting, American Energy, blah blah blah. I'm curious what you think about those sunset provisions and how this conversation ties into defending things like ESA, MBTA, Marine Mammals Act, and how hard will we have to go in order to defend those regulations?
Fred, can I start off with that? Because I've got a hard stop at the top of the hour, though.
That's 30 seconds, so go.
Yeah, okay, in 30 seconds. Well, I think, frankly, it recognizes it's designed to deal with the fact that, some regulations sit on the books and they never get revisited, and, to force agencies' hands in that regard. On the other hand, it seems to just underappreciate the importance of a consistent regulatory regime. And, there's real value in having rules that you can depend on. We'd hope to do an incremental change to the CEQ regulations in 2020, not start a pendulum swing wild ride, which we're on now. So I think we may be living the counterpoint to that sense that, well, we ought to take a look at these regulations every year or so. I mean, actually having them sunset, could be really quite disruptive. So, and with that, on that happy note,
Wait,
I'm gonna
before you go, everybody in the room, on the count of 3, Thank you, Ted. In a very sing-songy voice. Ready? 1, 2, 3.
Thank you all. Sorry I can't be in Denver.
All right. That's good. Let me say one more thing about the rules. I'll come back to you, Matt. All right. So let's talk about sunsetting rules and stuff from a different perspective. In the phase 2 NEPA litigation that Iowa and the other states brought in North Dakota, what was one of the claims that dealt with that very issue? The aspect dealing with categorical exclusions in phase 2 that ordered agencies to revisit their categorical exclusions every 5 years. Does anybody remember that? It seems so long ago when the phase 2 rules were final, but that was in there. I don't need this anymore, because Ted's off.
No, but still a couple.
Are there people on the phone?
Yeah, some people are.
Oh, okay, sorry. We're remote and we're cool. All right, so the states objected to that regulation, which seemed to me pretty common sense, because just like regulations get stale, some agencies in their list of categorical exclusions, or as long as you're on, you read some of the agencies don't do that anymore. There's a categorical exclusion for actions that they do not take. Programs that have not been funded for generations. So what CU is saying, in order to be fresh, be fair, revise them every 5 years to see whether the states objected, and in one of the lesser known aspects of the wacky North Dakota rule, and I can say it's a pretty wacky ruling. If it was any other appellate court, I'd say the judge would be on shaky ground, but it's the so they're going to find a way to uphold the judge. But the judge found that the CQ was acting outside its authority to order the agencies to revisit their CEs every 5 years. Well, now fast forward to this executive order. How do you harmonize that ruling and an objection brought by conservative states with the executive order calling for sunsetting every 5 years? It doesn't make sense. It's completely inconsistent. And again, I think subject to right deference to the agencies and whatnot. If Congress says thou shalt regulate, and then one administration comes in and says, oh, by the way, you have to include a sunsetting provision after Congress has already said thou shalt regulate, what has changed? What has Congress done any differently? So of all the executive orders, I mean, there's hundreds of them, of all the executive orders that are out there, that one has a shelf life less than a head of lettuce, like the Prime Minister of Britain. Because from the Administration Procedure Act, it can't be true. It can't be true that you can automatically sunset it. Now, there could be legislative action that does that, because we expect regulations to be sunset because it's a problem that we're going to tackle now, or we expect it to be included, or budgetary authority will be on, maybe. But automatically, I don't think it has a chance.
Oh, well, thank you both for being here, because this is really important to talk about, and it's great to have this information. There's sort of an information vacuum out there now.
Not anymore, not anymore.
Right, exactly. And so talking about the seesawing back and forth of these regulations, I've heard Ted talk on an AASHTO call about how to make your documents durable, and those, what do we do to make our documents durable in the short term, in the long term, looking, 2 years down the road, because sometimes it takes that long to get over the finish line, whether it's ESA, EJ, GHG stuff. I know it's a tough question, but how do we navigate that in the current moment?
Yeah, so the question that we're getting here is that we've got the pendulum going like this, and somewhere in that pendulum you're going like this, right? You have to deal with it. Is it wise practice to follow the pendulum, in other words, to promote durable your reviews and documents? And the answer is absolutely not. So the principle that I proposed at the NEP meeting was that there are certain irrefutable principles of our work. If it's data driven, if it's driven by input we receive from our stakeholder public, if it's input we're receiving from our permitting agencies, because after all, we can't build our projects unless we satisfy the permitting agencies, all those things and others tend to reduce the peaks and valleys of the pendulum. They tend to lower the highs and they tend to elevate the lows. because there is some common ground there in the middle. EJ, climate. On one end of the spectrum, there's the stupid stuff. Just change the words. I hate that. As a lawyer, as a professional, I get the heebie-jeebies thinking about it. Just change the word. Come on. I trained for this. As a biologist, as a lawyer, I trained for this. I'm going to say, higher temperatures instead of climate change. I had somebody say that to me. Should we just say higher temperatures? Should we just say societal effects instead of, EJ? And I'm saying, okay, yeah, if you want to get past the algorithm and then, survive an agency review, maybe, but that doesn't solve your problem. Here's what does solve your problem. So you're dealing with data that says there are X number of crashes a year, X number of fatalities, Y number of costs, Y number of interference with a facility that's built. Is that an environmental issue? Is that a species issue? Or is that a safety issue? To me, it's a safety issue, pure and simple. Why lean into, and again, I love the speech this morning, and I'm going to buy his book, but why lean into the road is evil principle? Instead of the principle of how do we deal with it? We need both. We need mobility and we need to deal with the effects of mobility. So why not deal with it as a safety issue, pure and simple? Environmental justice. Oh, it's an equity issue for disadvantaged communities. It is true. But an equity issue for communities affected by air quality immediately adjacent to a project are affected by air quality. You don't have to utter the word disadvantaged community. You don't have to utter the word equity. It's an air quality analysis. Then do the damn air quality analysis. You're in that strata in the middle. So you're not saying the words for this administration. You're not leaning into the principle like the last administration. You're relying on the data and you're relying on the information. And it's irrefutable. The suggestion I made in NEP, and I encourage you to listen to a podcast that's out now for environmental professionals radio. I was on the panel. I said, one thing always remains constant. Wow. Regulations come this way and regulations go that way. Integrity. Integrity is integrity. Don't lose yours. Do analysis that matters, that's substantiated, that's real, and let the chips fall where they may. Because the strange thing about this world is that it keeps on spinning. It's a strange thing. It does. Morning, night, it keeps going. And I can be back here for 2 more ICOETs. It's every 2 years, right?
Yep.
I come back in 2 ICOETs and we keep talking about the new policies of the Ocasio-Cortez administration.
Yeah.
Just as easily. I mean, could we? It's possible. Or something in the middle. We just don't know. But what we do know is analysis of data is analysis of data. If it's a safety issue dealing with wildlife crossing, then by God, call it a safety issue. And don't be leaning into the argument that roads are evil, please. It's our world. You want to solve climate change? You're going to have to be building solar panels over thousands of acres of land in the West. And it's going to interfere with habitat. Want to solve climate change or not? Don't call them evil. Call it like it is. We're trying to get results to solve a problem. And there are trade-offs. And we're not going to be paralyzed by those trade-offs not to make decisions anymore. That's where I take issue with our speaker. And that's what Ezra Klein is saying. So I'm a big advocate of what he wrote if you haven't heard already. There's another book that's a companion book called Why Nothing Works. Read that one too. I was interviewed for that book by a professor named Mark Dunkelman, Dunkelman, Mark Dunkelman. So if you're going to read 2 books this spring and summer on the beach, near beach weather, today it's beach weather outside. Mark Dunkelman, Why Nothing Works, and Ezra Klein's Abundance. You won't regret it, and I think you'll bring a new perspective to all of your work. And I think a positive perspective. That your work still matters, it's still valued, and integrity still counts. We need We just need to get to the work of solving our country's problem. Last minute for last question. All of them are great. Yes, sir.
Say you had a client wanting to take one of these 28-day EISs, and 3 or 4 years, things change. Is that client, is that the person, is that company set themselves up for failure because they're gonna just get litigated in lawsuits either in 3 or 4 years or within the 28 days because, yeah, it's not a real spelled out process.
Yeah, Josh asked, so if you're approached, if I was still a lawyer, well, I get approached as a consultant. Yes, if I'm approached by a client that wants to take advantage of the 28-day EIS, what am I telling them? The short answer is, please don't be the guinea pig. I hear you, and I'll work with you, but, let Conoco, or let Marathon, or let some other, let them try, let's see what happens. Because ultimately, you're gonna save time on the front end just to be pooped on the back. And it's less of the pendulum for 4 years from now, I think, than it is, I don't wanna be the one testing this. Because you could have a perfectly, relatively unobjectionable, mild-mannered type approval and project. Why put that bullseye in your back? Unless you are the type of client, and there are others like that, that say, damn right, I'm like Superman, I'm gonna put the bullseye right on my chest. In which case, the answer is, I'll see you in 28 days with your EIS, sir. But the first piece of advice will be, if you want to do it, that's fine, but let's consider whether we have options to get there.
I've kind of heard NEPA really was started because of lawsuits, like projects were getting caused with lawsuits. Is that
No.
true?
No, not really. I mean, the derivation of NEPA was born out of the 1960s movement that we really weren't thinking about environmental values so much. It was really born out of Rachel Carson and the river being on fire. It was born out of an ethic saying, we're losing track of things. But again, that's why you have to read the book. Because in the big political science, I know we're over time, the big political science picture was that things got so crazy that we needed a whole generation of environmental law to sort of rein in the government and rein in the power that we gave the government. The classic case is the power broker about Robert Moses in New York. He got a lot of shit done, didn't he? How did he do it? By building left and right and in a slightly
Come on, Fred, I knew you better than that.
You heard my tone of voice, you know what happened. So the whole series of laws of the 1960s to the 1970s were designed to rein in government activity. Because the theory was that we'd given too much authority to government, and look what happened. We just went too much overboard. Fast forward, Prince born, Prince mistress, Prince gets married, Prince had kids, Prince here speaking. 50 years later. And now we're thinking, oh, wait, maybe we're reining in government too much. Maybe we got so good at saying no that we're not really being good at saying yes for the things that we really need. NEPA was born from the former ethic. The objections to it are because we now veer too much to the other ethic. And as we all would agree in this room, it's overblamed for the collection of requirements and permits and reviews and whatnot, but it's handy because it's there, right? So again, the initial advice would be, let's see how this plays out just for a little bit, sir. And then if there's a green light, I'll see you in 28 days. But in the meantime, let one of your brethren take the hits and the punches. Otherwise, go to my friend Ted, make him a couple of shekels. He'd be happy to defend it. If you want to build that into your budget, you could do it. You know, when we spoke at NEP about the Seven County infrastructure case, the gentleman who funded the project spoke. It was fascinating. So it was the lawyer and the company, but the guy was the president of the company who funded the railroad. And he talked about the decision to bring the case to the Supreme Court. Because if he said no, then me and my colleague who litigated the case, and Paul Clement, who argued the case, it's like we didn't exist. He had to say yes. And his rationale for saying yes was, you know, darn it, if we're gonna get stuff done in this country in a way that matters, then I'm gonna fund the effort to get to the court. But he and his company had to get to that decision, which was no surefire thing. Remember, what percent of cases get accepted and all that kind of stuff? Long odds. And yet he decided to do it. Because he and his company had invested 4 years in the project. They listened to the community, they've done an alternatives analysis, they built the railroad where there'd be few property impacts, they did a whole bunch of mitigation for wildlife and whatnot. They felt they had done the right thing. And he didn't want to walk away from it. It was fascinating to hear. All right. You guys are great. I'm around all the way till Thursday, Friday, and